Hello, Professor. My name is Drell Wafula, and this is my presentation on Assignment 2 on ethical dilemmas and complex issues. So we'll start by the first scenario, which involves Anthony Rose, a security researcher. Uh, at DEFCON, security researcher Anthony Rose revealed that 12 out of 16 tested Bluetooth logs had major security flaws, including plain text password transmission, easy admin password changes, and vulnerability to remote attacks. Despite reaching out to the manufacturers, only one manufacturer responded, while another kept selling its insecure product on Amazon. Rose watched the news and found out that crime rates to these logs increased. So Rose considered whistleblowing anonymously, reporting to the regulators, or sharing his findings with a secure log company for marketing use, but feared legal consequences. For example, assuming Anthony lives and works in the United States and is subject to United States law, explore and describe his alternatives from a legal and from an ethical perspective both. Okay, so first we need to understand the United States legal system. The United States legal system is based on a combination of federal and state laws, as well as the Constitution. The US legal system also includes common law, which is a law established by the court. So this is a book. This book it talks about the law of the United States. So let me just show you the book, the reference of the book. This is the book that talks about the US legal system. I can see it. It's here. The US law. Okay, let's proceed. So Anthony Rose's discovery of major security issues in Bluetooth locks present various legal challenges. Okay, the first legal challenge is Computer Fraud and Abuse Act, the CFFA. The Computer Fraud and Abuse Act, CFFA Act, laws prohibits unauthorized access to computer system. If Ross tested the lock without getting the permission from the manufacturers, he might face legal trouble. However, if he conducted ethical hacking with the goal of improving security, he might have a defense. So this act, it can be found here. This is the reference, Computer Fraud and Abuse Act. Let's just go to it. Mm-hmm. It's loading. Okay, you can see it. This is the Computer Fraud and Abuse Act. It states that um, it was enacted in 1986 as an amendment to the first federal computer law to address hacking. Over the years, it has been amended several times, most recently in 2008 to cover a broad range of conduct far beyond its okay. The CFAA prohibits intentionally accessing a computer without authorization or in excess of authorization. Yeah. Okay, this is the reference. Okay. Also, we have another reference. See, this is a cybercrime, an overview of the federal computer fraud and abuse statute and related federal criminal laws. Let's just Okay. This is the second reference as per the first act, the CFAA. Okay. Okay, the second one is Consumer Product Safety Act. The Consumer Safety Product Act, the CPSA, is a US law that empowers the Consumers Product Safety Commission, CPSC, to regulate most consumer products, allowing them to set safety standards, investigate potential hazards, and initiate recalls for products deemed to pose unreasonable risk of injury or death to consumers, essentially protecting consumers against dangerous products in their market. In this case, since the flawed laws put consumers at risk, Ross could have reported his findings to the Consumer Product and Safety Commission to ensure they take action to protect the public. So this act, you can find it here at this reference or Consumer Product Safety Act. This is the Consumer Product Safety Act. Mhm. You can see what it covers. Mhm. Yeah. The public should be protected against unreasonable risk of injury associated with consumer products. Yeah. So this is the act. Okay. Let us proceed to the third one, which is whistleblower protection under the Dodd-Frank Act. And this act states that individual who reports potential security law violation to the Securities and Exchange Commission, the SEC, are granted significant whistleblower protection, including the right to confidentiality, protection from retaliation by their employer, and the potential for monetary awards if the information leads to successful enforcement action by the Security and Exchange Commission. If Ross disclosed this security risk to the government agency rather than directly to the public, he might be protected under the Whistleblower Act, the whistleblower law. But if he made the findings public before going through the proper channels, he may face legal threats from the manufacturers. Okay, we have a reference to this act on Whistleblower Protection Act. It's here Securities Whistleblower Incentive and Protection. You can just go to the reference to see what it entails. So you can see what these security whistleblower incentive and protection contain. Can peruse. You can see, can get rewarded. Yeah. Okay. Okay. Uh, Anthony had some ethical dilemmas, or we can see them here, as Ross had to decide how to share his findings responsibly while avoiding the legal trouble. He had several options. The first option was private disclosure versus public exposure. The ethical choice is usually to inform the manufacturers first, but since most of them ignored him, he had to consider whether to escalate to the regulators. Anonymity versus public accountability. Reporting security risk anonymously could have shielded him from retaliation, but transparency might have given more weight to his claims. Also, we have personal gain versus public safety. If he had sold his findings to a competitor, it might have benefited him financially, but it's the same way it could have raised ethical concerns. So the best course of action that Ross could have taken is first they could have reported the security flaws to the CPAC to ensure consumer protection. Yeah. The second one is they could have published a research through professional cybersecurity channels to maintain credibility while reducing the legal risk. Also, Ross could have worked with cybersecurity experts to create awareness and encourage manufacturers to fix the glitch, the flaws, the flaws. Yeah. So, okay, okay. Now we'll move to the second part, the question. Okay, this is the second scenario, and the scenario states that at DEFCON, two members of Salesforce Red Team plan to present their newly developed security tool, Pistol, an automated malware generation tool designed to help security teams test and improve their own system defenses. The tool could create and deploy malware in minutes, reducing the time for red team operations. Initially, they intended to release the Pistol code as an open source to benefit security researchers, but Salesforce executive intervened at the last minute, ordering them to cancel the presentation and not release the code due to concerns about the potential misuse by malicious hackers. Despite this, the team proceeded with the presentation but omitted technical details and did not release the code. As a result, both employees were fired, lost their job, lost their company shares, pension, and benefits, and also they were blacklisted by Salesforce. Assuming that the team members work for Salesforce Canada, lives in Toronto, and are subjected to the Canadian Ontario law, discuss the legal and ethical aspect of the scenario. The Salesforce Red Team members faced serious legal issues when they decided to present their findings despite their company's objection. The first legal issue was on breach of employment contract. Uh, and this act of breach of employment contract states that when employees sign an employment contract, they agree to follow the company policies. If a company explicitly orders employees to do or not to do something as part of their job duties, disobeying the order may be seen as disobedience. Employees must follow their employer's policies because in this scenario, Salesforce ordered the red team to cancel their presentation, but instead they proceeded with the presentation. This is seen as a contract violation, justifying their termination. Employees also can challenge they can challenge their termination if they believe it was unfair or unjustified. So under this act, the Ontario Employment Standard Act, I have a reference to this act. Let me show you here. Yeah. So this is the Act, Ontario Employment Standard Act, a quick guide to employers. You can see the Employment Standard Act, Ontario sets down the minimum standards for basic condition of employment, including wages, leaves, absence, work hours, overtime and notices, and severance pay obligation upon termination. It also lays out the rights and duties for employers and employees. So this is the act. Yeah. Okay, let us proceed to the second one, which is intellectual property laws. This act governs intellectual property rights in Canada. It protects original works and ensures that the creators have control over how their works are used, distributed, or monetized. Since the malware tool was developed while they were working at Salesforce, the company the company they work for as is the owner of the rights. If they reveal too much information, they could be in breach of the intellectual property laws. So this act, we have a reference from here, which this act states that the the employer has the control over the meat pistol because the the mm, the red team made the mm, made the made the malware under Salesforce. They were working under Salesforce when they made the malware. So the employer has the full mandate to the malware. So we have here a reference, which is the protection of intellectual property. Let's go to the reference. Here it is. This is the protection of the intellectual reference. As you can see, cookies. You can see it's here. So it's here, a Canadian patent grants its owner the exclusive rights to make and use and sell an invention in Canada as defining the claims of the patent for a period of 20 years from the date of application. Mhm. Mhm. You can see here it says it is important to distinguish between the authorship and ownership. According to the Copyright Act, the author of a work is in principle the first owner of the work. The first owner of the copyright created by an employee within the scope of his or her employment is the employer unless there is an agreement to the contrary. Yeah. Okay. So the third one is Criminal Code of Canada, which is on unauthorized use of computer systems. Distributing tools can be used for hacking or unauthorized access could lead to criminal liability depending on intent and use. If the tool could be used for hacking or cyber attacks, releasing it its source code might be seen as enabling illegal activities, potentially leading to criminal charges. So we have the reference to this. It's called the name is unauthorized use of the computer. You can find it here. This act, it's here. This is the name. Everyone is guilty of an indictable offense and liable to imprisonment for a term of not more than 10 years, or is guilty of an offense punishable on summary conviction, who fraudulently and without color of right obtains direct or indirectly or any computer service. Yeah. So this is the act on unauthorized use of computer. Yeah. Okay. So the red team members were faced with some ethical dilemmas here. The red team members had to balance their professional credibility with their employers' directives. So they had ethical dilemmas. Like the first one here, we have career impact versus company loyalty. Canceling their presentation could harm their reputation by defying Salesforce led to, and also by defying Salesforce, it led to severe consequences. The second one is cybersecurity advancement versus risk of misuse. Making the tool open source could help security researchers, but also cyber criminals could have exploited the meat pistol tool. Also, we have proportionality of punishment, being fired, losing company shares and pensions, and being blacklisted. Raise ethical concerns about whether the punishment was fair or not. The best action for the red team, for the team that they could have taken is the first one. They could have followed company policies to avoid serious professional consequences. Also, they could have seek legal advice from a legal expert before deciding to present sensitive cybersecurity research. Also, the third one, they could consider a controlled disclosure where details are shared only with the security experts under non-disclosure agreements instead of public release. Yeah. This is the second part of the assignment, and it was about to choose the different topics. You choose only one topic among the topic that you gave us. So I chose the topic on Joe Biden's executive order on AI. So the question states that an analysis of Joe Biden executive order on AI, what was covered, what is missing, to whom is the order addressed, what forces does the order have, why was the order issued when it was, are similar rules in place in other jurisdiction, how does this order fit in with existing USA legislation on AI, security and defense. Okay. In October 2023, President Joe Biden issued, the former President Joe Biden issued a comprehensive executive order on AI. Biden's executive order on AI was meant to make sure AI is safe, fair, and beneficial while keeping the United States competitive in AI development. The key areas that was covered in the executive order was number one, AI safety and security. The order requires that the development of AI safety guidelines, especially in critical sectors such as defense, healthcare, and finance. The executive order mandates the National Institute of Standards and Technology needs to develop rigorous guidelines and best practices for AI. For example, it included like pre-deployment testing, such as the red teaming, to identify and mitigate potential vulnerabilities in AI models. Developers of significant AI systems were required to share safety test results with the federal government. The second one was privacy protection. Recognizing AI potential to exploit personal data, the executive order calls for federal support in developing privacy-preserving technologies. It also urges Congress to enact bipartisan data privacy legislation to safeguard individuals' information. The third one was government oversight and regulation. Federal agencies are instructed to create guidelines for AI deployment, ensuring compliance with security and ethical standards. This includes hiring AI professionals and establishing clear guidelines for AI procurement and use. Also, advancing equity and civil rights. The order directs federal agencies to combat algorithmic discrimination in sectors like housing, employment, and criminal justice. This includes providing guidance to landlords and federal contractors to prevent AI-driven biasness. The fifth one is promoting innovation and competition. To maintain United States leadership in AI, the executive order emphasizes attracting global AI talent by streamlining processes like visa. It also supports public-private partnership and provides resources for AI research and development. You can find the reference of the executive order in these two, in this link and this one. So let's just go and have a look at it. Mhm. There you go. I can see the executive order here. Mhm. The executive order on the safe and secure and trustworthy development and use of AI by Joseph Biden, the United States Office of the President. Mhm. Okay, this is the order. You can see. Yeah. Okay. Also, this is the second reference to the executive order. So let's just go to it. Okay, this one. Yeah, this is from Claire Michael. See. Mhm. Okay. So let's do some dig. Let's dig on the executive order, uh, and we see it had some gaps and challenges. Despite its comprehensive nature, the EO has several gaps. The first gap was it had a lack of clear enforcement mechanisms. The executive order sets guidelines but does not establish strong penalties for companies that do not follow the order. Without laws to back it up, compliance depends on companies voluntarily following the rules. The second one, AI bias and discrimination. The executive order pushes for fairness, but identifying and fixing bias in AI is complex. AI systems learn from existing data, which can already be biased, making it hard to ensure true fairness. The privacy concerns, the order encouraged privacy protection, but the United States on United States laws on data privacy are still weak compared to the to countries like Europe. They have the policies like the GDPR. So the EO lacks stronger rules on how AI should handle personal data. Also, it faced international competition with the while the executive order focuses on AI development in the United States. Other countries like China and the European Union are moving fast with their own AI strategies. The US needed a long-term plan to stay ahead in, in terms of AI, speed of AI innovation. AI is advancing faster than the regulation can keep up. So government agencies might struggle to monitor and adapt to AI risk and emerge as they emerge. Yeah. So let's see to whom the AI the executive order was addressed to. The executive order addressed government agencies, tech companies, businesses, researchers, and global partners to make AI safer and more responsible. The federal agencies, for example, the National Institute of Standards and Technology, NIST, was to set safety and security standards for the AI. Also, the Department of Commerce to oversee AI system testing and risk assessment. Department for Homeland Security to prevent AI threats to the national security. Also, the second people were the AI developers and tech companies. As you can see, major AI companies such as the OpenAI, Google, and Microsoft were required to test and share their reports on powerful AI models with the government. The third people who the EU was addressing were the employers and the businesses using the AI. Employers using AI in hiring, learning, or customer service had to ensure AI wasn't biased or discriminatory. Research institutions and universities encouraged to advance AI research, develop safety tools, and train future AI professionals. So we can find this one on this is the CBS News on President Biden's EO. This is a YouTube. This is a YouTube link. You can just see it's here that it was on President Biden's the day that he signed the executive order. So just it gives us more of what the order entails, the people it was addressing to. Yes, it's a YouTube video. So, okay. Okay, let's go. Let's go to the other. Let us continue. Are similar rules in place in other jurisdiction? Yes. Other jurisdictions have similar AI rules. Here's a comparison of major AI regulations worldwide. For example, we have the European Union, the on AI Act. So the European Union on AI, it was approved on 2024, in 2024, and classifies AI systems into risk levels. For example, high risks like facial recognition faces strict regulations. It bans harmful AI, e.g. the For example, there's social scoring, like in China. It requires full transparency for AI-powered decision, especially in hiring credit and law enforcement. It also enforces fines of up to 35 million pounds, or 70% of the global revenue for violation of this act. Mm. So the second one, the second one is China proactive AI regulation. China has strict rules for generative AI, such as the ChatGPT, requiring that the government should approve the AI before deployment. AI generated content must be labeled to prevent misinformation. Heavy surveillance and restrictions, especially for politically sensitive AI applications. So this is the European Union Act on AI. We can just have a look at it briefly. So continue. Mhm. The European Union AI Act. So this one, this is the act. Okay. Also, we have the policies approach to artificial intelligence-based technologies in China, the European Union, and the United States. So this is a comparison of both the AI regulations that in both countries, in both continents, China, United States, and the European Union. So, okay. So we can just open the PDF, have a look at it. So this is the PDF. See, go down here. You can see it's a comparison of the three. It's on China. Mm-hmm. Have the European Union and also the United States. Yeah. Okay. Okay. So let us continue. How Biden's AI executive order fit in with the existing US regulation on AI. Biden's executive order did not create new AI laws, but it strengthened and overset the three key areas. The first key area was AI safety and security. Uh, for example, it expanded the AI red teaming, such as testing AI for security risks before deployment, and required AI companies to report security test results to the United States government through the Department of Commerce. It aligned with the national cybersecurity strategy by addressing AI-powered cyber threats. The second one is AI in defense and national security. The EO strengthened AI use in military by ensuring AI systems are tested for security risks before deployment. It also worked with the Department of Defense, DoD, to create new AI safety measures for defense technologies. Civil rights and AI ethics, which complemented the AI oversight by requiring AI systems to provide to prevent bias in hiring, housing, and lending. It also encouraged stricter AI privacy rules to protect users from misuse. So we have here some two references that support this. The EO can just check it them. You can just check them out. This is the USAI regulation guide. Okay, you can see this is an AI regulation guide that discusses the state of US regulation of artificial intelligence. Uh, and it said that regulation of artificial intelligence is still in infancy, perhaps with the exception of autonomous vehicles, which have seen the most legislative activities worldwide. Many countries have just issued their national plans, guidelines, or codes, which often highlights essential principle for developing ethical AI without having passed much substantive law. Notable examples include the European Parliament resolution on civil law rules on robotics of 2017 February. Okay. So can see the other one, which is the America's first AI legislation. There you go. So, see, in December 2017, a bipartisan group of the United States senators and representatives introduced the fundamentally understanding the usability and realistic evolution of AI, Artificial Intelligence Act 2017. So that was my presentation on the executive order of the former president of the United States of Joe Biden, and I'm aware that when the current president of the United States has he has made when he went in office, he has signed off the EO that was presented by Biden on AI. He has come with a new amendment on how AI is to be used. So that was my presentation, sir, and hope you have a good day. So I'll stop the screen now. Thank you.